And also, who's responsible for what, carries the primary, I don't know if to call it signatory value or what, but who's responsible for what? If the
Yes.
memo shows that as well.
Mm-hmm. So,
right.
Right. So the binding effect of the M&A is that it's binding on the company to its members.
Okay.
And it's binding on members in relation to the company. And it's also binding between the members themselves. And there's no binding in relation to outsiders. So that's what the M&A does. It binds the company to its members. Is binding on the members in their relation to the company, and is binding between the members.
Right.
M&A together, they constitute a contract between a company and its members. And that contract is between the rights and the liabilities of the members. That's what the M&A does. So you'll see in the IBC Act, it keeps saying subject to any limitations in the M&A. Because capital refers to the investment by the members. And the M&A is binding on the company and its members. So a member can sue the company just as the company can sue the members. And they do that to enforce and restrain any breach of the articles. So always remember that. Every time an action is taking place, it's always subject to the limitation of the M&A. And remember, a company can adopt the model M&A or it can draft its own M&A. So when we talk about shares, a share is actually an interest of a shareholder in the company and is measured by a sum of money for the purposes of the liability. And a share is a property. It can be sold, it can be given as a gift, it can be transferred. And once you invest in a company or you are given shares as a gift, you have certain rights. And those rights depend on the type of shares that you have. So that means that rights attach to the classes of shares. And those classes is based on what's defined in the articles. So under the IBC Act, it tells you that each share can be issued for money, or it can be issued for services, or it can be issued for personal property. It can be an estate in real property. It could also be a promissory note or other binding obligation to contribute money or property or combination thereof. That's what the IBC Act says. Now, let me see if I could find, under the Companies Act, it says, the shares or other interests of a shareholder in a company incorporated under this act are personal property capable of being transferred in the manner prescribed by the articles and are not the nature of real property. And each share, unless the articles otherwise provide, shall, in case of a company having a share capital divided into shares, be distinguishable by its given number. So all that is saying is that when shares are issued, then they're issued by number. Now in this modern day, a lot of companies do not even issue share certificates, but you would still have a number. So what are the general rights which attach to shares? Normally, one is to attend general meetings and vote. Shares normally carry one vote at each general meeting. Although you could also have non-voting shares, or you could have shares that have multiple votes. The next right you have by holding shares is you have a share in the company's profits. Dividends represents the company's distribution of profits of a certain amount paid each share. Shareholders are paid these dividends as a share in the company's profits, and dividends may only be paid if the company has made a profit. And you'll see that even for regulated entities. Whenever they're going to pay dividends, they cannot pay dividends from the preceding year's profit. They have to do it from the year before that. Dividends may be only paid if the company has made a profit to the extent to which it decides to distribute them in accordance with the Articles of Association. Third, to final distribution on winding up liquidation. If a company is wound up and all the creditors have been paid, the remaining assets are available for division and distribution amongst the members, shareholders, by a return of capital or a distribution of surplus capital. And remember now, it depends on the type of shares. Certain shares have priority over others. That the company be run lawfully. That is another right of a shareholder. Only members of a company have the legal right to sue that make the company act lawfully with some restrictions. So types and classes of shares. Under the IBC Act, it says that under section 27, it says the shares of a company are personal property and are not of the nature of real property. And it says the company shall state in its articles whether or not certificates in respect of its shares shall be issued. Because remember, I just said to you, you do not have to have a share certificate. And then it says that a share register should be kept at the registered office. Under the Companies Act, it says the articles may provide for the issue of more than one class of shares, and if they so provide, the rights, the privilege, restrictions, and conditions attaching to each share shall be set out in such articles. And where there is no provision in the articles, a company may, by resolution of shareholders, resolve that all of its shares, or if its capital be divided into shares of different classes, that all of its shares of a particular class rank pari passu for all purposes, and in either case, either already issued and being fully paid up, or thereafter to be issued as fully paid up, need not thereafter have a distinguishing number. And then it says, if the articles so provide, no shares of a class of shares may be issued unless the shares are first being offered to the shareholder of the company holding shares of that class. And those shareholders have a preemptive right to acquire the offered shares in proportion to their holdings of the shares of that class at such price and on such terms as those shares are to be offered to others. And it says in subsection 4 of section 36, continuing, it says the articles provide for the preemptive rights referred to in subsection 3. The shareholders of the company have no preemptive right in respect of shares to be issued by the company. A, for consideration other than money. B, as a share dividend. Or C, pursuant to the exercise of conversion privileges, options, or rights previously granted by the company. So as the Company Act says, you could have different rights on different classes of shares. The main types being preference and ordinary shares. Shares may be voting and have multiple voting rights. Shares may also carry additional voting rights on particular resolutions. Companies have different types and classes of shares with different voting, dividend, and/or capital rights. Normally, these different rights are used so you can attract different types of investors, or they do it for tax efficiency purposes, or to extend or limit management control through voting. So an ordinary share normally has one vote. They are entitled to participate equally in dividends if the company is wound up, or share in the proceeds of the company after the debts have been paid. They may be issued different classes of ordinary shares to allow directors to pay different dividends, exercise different levels of control, or to allow different rules with regard to share transfers. Preference shares have a preferential right to a fixed amount of dividend, and that's normally expressed as a percentage of the nominal value. So normally you could say, for example, $1, 6% preference share. Preference shares are often non-voting and sometimes redeemable. So as is usual, preference shares have priority either by the articles or terms of issue. They are entitled to repayment of their capital in full before the ordinary shareholders receive anything by way of repayment of capital. Where there are surplus assets left after the discharge of all the company's liabilities and the repayment of capital to all shareholders, the surplus is divided among ordinary and preference shareholders unless the articles provide to the contrary. Any rights given by the articles are exhaustive. That is, where the articles give preference shareholders priority of repayment of capital in a winding up, but do not refer to any further rights in the capital of the company, the preference shareholders have no right to participate in the surplus capital. And last, for preference shares is they're often not entitled to share in capital surplus. So ordinary shares, what are the advantages and the disadvantages? The disadvantage is that ordinary shareholders are entitled to a dividend only after the preference dividends are paid. The preference shares have preference as to capital. The ordinary shares rank behind the preference shares for repayment of capital on winding up, or where there is a reduction of capital by repayment. The preference shares must be fully repaid first. So because priority is given to preference shareholders, the ordinary shareholders are said to hold the equity share capital of the company. Now to look at an ordinary share and look at what are the advantages. The voting power of the ordinary shareholder is such as to allow them to control the resolution of such members. And this means that the director can be made to represent the ordinary shareholders. The voting rights of preference shareholders are adequate if they can vote when their dividend is in arrears, on resolution for reducing the share capital and winding up the company, on resolutions which are likely to affect their class rights. Another advantage of ordinary shares is that their dividends are not fixed and may increase substantially with the profitability of the company. Another advantage is that a company may issue bonus shares for which the shareholder does not pay in cash or make new issues at prices lower than outsiders would have to pay. And both of these are generally offered to the company's existing ordinary shareholders. The general principle is that the rights enjoyed by one particular class should not be varied by the holders of another class of shares within the company. That is, it is necessary to gain the consent of the members of the class whose rights are subject or proposed variation to agree to this process. Non-voting shares. They carry no rights to attend meetings or to vote. They're issued to employees as remuneration to be paid as dividends, and the preference shares are often non-voting shares. Redeemable shares are used on terms that the company will or may buy them back at a future date. The date and terms may be fixed. These shares may also be redeemable at any time at the company's option. The preference shares are normally redeemable. A company articles of association normally stipulate the terms and conditions for the issuance of redeemable shares. Deferred ordinary shares. These are shares on which no dividend is paid until other classes of shares have received a minimum payment or minimum dividend payment. Management shares. This class of shares carrying extra voting rights so as to retain control of the company in certain shareholders' hands. And management shares are normally used to allow original owners of a company to retain control after additional shares have been issued to outside investors. So you could have, in one company, you could have voting shares class A, you could have dividend shares class B, and then you could have capital shares class C. So the memo and arts may have provision in it that give protection to holders of a class of shares against the rights of their shares being altered. So what's the nominal value of shares? A company may have shares of nominal or par value or no value. So what's the difference between par value and no value? The Companies Act, Section 35, subsection 3 says shares may have a nominal or par value or may be of no par value. What does that mean?
Yeah, that it is a non-profit, maybe.
You mean no par value?
Like is that like in the example of a company that's limited by guarantee only? No.
Not really. You normally have that no par value. The prices are determined by the investors.
Oh, okay, okay.
Yeah, so it's more like what, like stocks on the open market.
So that's how like the so you could incorporate where you say that it's no par value and the investors can invest any set amount.
Mm-hmm.
So that's set in the memo and arts.
Yeah, it's also in that, not in the IBC, the Companies Act.
Okay.
And companies would do this just so they could avoid liability to stockholders should the stock price take a turn for the worse. So they set the price. So let's say the stock was trading at $5 a share, and the par value on the stock was 10. So that means that the company would be at a $5 per share liability. So you have the trade, and then you have the par value. So normally when you have no par value, the specification of the par value is not made in the articles, nor is it stated on the stock certificate. And most shares today that are issued at no par or low par. So especially like a lot of these fintech companies, they'll have a no par value. So what it means is that the investors will then state what they're willing to pay for the stocks on the open market. A par value.
Is that only for IBCs, or does that apply to CACs as well?
No, this is for CAC. The CAC section 35, section 3 actually states that shares may be of no par value. Whereas in the IBC, it just speaks to each share could be issued for money, services rendered, personal property, estate and real property, promissory note, or any other binding obligation.
Okay.
Because remember, that's why I'm saying when you read these, you can't assume that what's in the IBC Act is in the CAC Act. The IBC Act is done with less restrictions.
So, but how can, okay, so how would they be able to, I know the maximum share value that the company has to have to avoid, if you want to not get extra taxes, should be like 5,000 shares, but you could say 5,000 shares, but no par value.
You mean for an IBC?
No, for a CAC. It could be a maximum of 5,000 shares with no par value, and it's fine. Cool.
Yeah.
Okay, cool.
But they set the par value, you know. They say what they're willing to pay for.
This is set in the memo in ours?
No, the investors paid it.
Oh, the investors, but okay.
Uh-huh. That's what the investors are willing to pay.
But if you said, okay, so in the example where the par value is set at $1, can that be changed, or
Yes, it can.
does it have to?
Doesn't have to be
Okay.
$1.
All right. So I'm just thinking in the example of you incorporate and say that it's set at a par value, but then you have a potential investor coming in and they want to invest more than the par, like the dollar amount for each share. Like, yeah, how would that work?
Like that. Then you
Right.
probably have, then if your articles allow for it, then in class of shares. If they're willing to pay more.
Okay. So if say again, if the articles allow, because you broke, yeah, I couldn't hear you.
Oh, I said if the article allows, then you can issue another class of shares.
Oh, in addition to
Ordinary
the
shares, you do preference shares.
Oh, okay. But you can't go in and change the share value once it's incorporated at whatever dollar amount.
Oh, I see. I mean, changing if the articles don't permit.
Okay.
I'm gonna look for that for you. We'll come to that shortly.
Okay.
Yeah, we'll come to that shortly. So we know what share capital is, and we know there are different types of capital. Because once a company has a capital, it has statutory and contractual rights. So you issue the shares, and from the accounting side, that becomes the capital of the company. So the nominal capital is the nominal value of the shares, which it may issue. And a company can't issue shares beyond its nominal capital. The issued capital is the total of the nominal value of the shares that are being allotted. The difference between the nominal and the issued is unissued. When you hear them say paid up capital, that's the amount that the shareholders are paid for. Called up capital is paid up capital plus unpaid up capital, which the company has called on its members to pay. So the value of a share depends on the number of shares offered by sellers and sought by buyers at a particular time. The amount sought and offered for shares change daily, and so does the ruling price. If shares are listed on the stock exchange, the value of the shares is the price at which they are currently quoted on that exchange. The nominal and paid up value of shares normally serve as a measure of the shareholder's liability to contribute towards payment of the company's debt and calculating dividend payments to which he is entitled. The nominal value provides no measure of the real value of the share. So company law is not concerned with the real value of shares. Although the real value of shares is a practical concern to the shareholder, the value of a share depends on the number of shares offered by sellers and sought by buyers at any one time. Now, the shareholder must pay the nominal value or a greater issue price of his shares to the company in cash. Remember, in the IBC Act, it says it doesn't have to be paid in cash. A company may also allot shares which are credited as paid up to an agreed amount for consideration other than cash. Whether shares are issued for payment of cash or for consideration other than cash, they cannot be issued at a discount. The allottee and any subsequent holder of shares are liable to pay the company the amount of the discount in cash if the shares are issued at a discount. So if you look at the Companies Act, it says share issue. The directors of a company may, if so authorized by a resolution of the company or its articles, exercise the power of the company to allot shares in the company, grant rights to subscribe for shares in the company, or issue an instrument that allows for the conversion of any of the value of the instrument into shares into the company. And the directors may, where authorized, exercise the power of the company under subsection 1 for a particular exercise of a power or for its exercise generally, and such power may be unconditional or subject to condition. And for consideration under CAC, it says a company may not be issued, a share may not be issued until it is fully or partly paid in money or in property, or for past service that is the fair equivalent of the money that the company would have received if the share had been issued for money. And it explains further, it says, in determining whether property or past service is the fair equivalent of a money consideration, the directors may take into account reasonable charges and expenses of organizations and reorganization and payments for property and past services expected to benefit the company. And here under the CAC, similar to the IBC Act, it says dissimilar. It says property does not include a promissory note. Whereas under the IBC Act, it said it includes a promissory note. So shares are allotted for cash when the shareholder agrees to pay their nominal value or higher issue price by a legal tender or by a check or negotiable instrument. Shares are also allotted for cash when the company is indebted to the shareholder and they agree that the debt will be discharged by crediting the shares as paid up by an equivalent amount. A creditor may also agree with the company that his debt shall be paid by crediting the shares of another person as paid up by an equal sum. A transfer of property to the company, example, land, buildings, or other tangible property, may also be consideration for the allotment of shares other than cash. Therefore, a contract may be made for the allotment of shares for consideration of cash or consideration other than cash, and may indicate the number of shares to be allotted and consideration provided. Now, like I said, under the IBC Act, you don't have to issue a share certificate. I didn't put the section here under the CAC. I don't want that one. A share certificate is issued by a company certifying that on the date the certificate is issued, a certain person or entity is registered or is the registered owner of the shares of the company. The certificate is prima facie evidence of a member's title to the shares. A company normally issues one certificate in respect of all the shares issued or transferred at a particular time, but the shareholder may request split share certificates. At common law, a company will be prevented from denying statements in a share certificate against a person or entity that has relied on the statement. So what's the key information in the share certificate? It gives you the company name and authorized share capital, the number of the share certificate, the name and address of the shareholder, the number of shares held, the class of shares, the amount on the share, the nominal or par value of the shares, the name and signature of the director or the person authorized in accordance with the Articles of Association, the date of the issuance of the share certificate, the company seal, and on the reverse side may be the share transfer form. Any questions so far?
Yeah.
Go ahead.
Who prepares the share certificate? Is that something that's done at the Register General or
Company secretary.
The company's secretary? So each individual, the secretary within the company that was formed creates the share certificate?
Yeah, that's the corporate secretary now.
not
Okay,
corporate.
so let's just say it's an IBC. If it's an IBC, then an IBC has a registered agent with a financial corporate service provider. In that office, that team of employees, whoever's assigned that file would prepare the certificates.
What if in the case where it's a company that just got, that used an agent, would the agent then be responsible for drafting it, or the secretary within that said company? For a CAC specifically, not an IBC.
Yeah, now I know you're speaking of a CAC. So you're talking about a standalone company?
Right, that's not assigned to a corporate
Right,
service.
yes.
Right.
Standalone means the
Right.
corporate secretary prepares.
I didn't hear you kind of
No,
broke
I
up.
was saying the corporate secretary prepares that certificate.
Okay. So they would have to go to a registered office to get it prepared?
No. In a standalone company, let me give you, say Kelly's.
Uh-huh.
So Kelly's. So Kelly's has shareholders. When they have a board meeting, where there's a board of directors meeting or annual general meeting, there is a person that is assigned from within the company as the corporate secretary, the person that takes all the minutes for the meetings, the person that sends notices for the meeting. That's the person that prepares the certificate.
Okay.
Yeah. You get it now, or you still confused?
No, I got it. I got it.
Why? That person may just be you.
Right.
So you'll be responsible for preparing it.
Does the share certificate have to get stamped by the Registrar General once it's prepared, or that's not mandatory? Hello?
I think she got knocked off.
Oh, okay.
Hi, sorry for that. Internet just dropped.
Okay.
Okay, so
Did you get
okay.
that last question? Or
No. No,
I
go
was
ahead.
asking if the share certificate is required. Is it a requirement for the share certificate to be stamped by the Registrar General, or that's not necessary?
No, that's not necessary. Why is it stamped?
Okay, thank you.
Remember now, once you issue shares or you cancel shares, you as a corporate secretary, that's reflected on the register of members. And then you'll also reflect that on the annual statement. Those two documents for CAC company are filed with the registrar. The registrar doesn't see the certificate.
Okay, got you.
Okay. So on the reverse, the share transfer form on the reverse, it will tell you to stipulate the name of the company, the name and address of the person that the shares may be transferred. They're called the transferee. The name and address of the person currently holding the shares, that's the transferor. The number and the value of the shares, the signatures of the transferor and the transferee, and their witnesses. The company secretary's name and signature, and the date of recording of the transfer in the register of members. So until that share transfer is recorded in the register, it is not effective. So the procedure is a resolution of the shareholders is prepared in accordance with the articles to approve and authorize the share transfer. So yes, you have someone who wants to transfer shares or give their shares as a gift. It has to go through a process in addition to preparing or issuing a new certificate or recording it in electronic form of a new certificate. There is a process to go through. One, you need a resolution. The existing shareholder completes the share transfer form and executes the form by signing it and having it witnessed. The person or the entity to which the shares are being sold or transferred completes the transfer form and they do the signing and the witnessing. And then the share transfer form is returned either to the corporate secretary or to the administrator at the FCSP. Once it is recorded, then the old share is canceled. If you're doing it electronically, then you would type in canceled and you'll put the date. Now, the Act also allows for you to vary class rights. And that's under the CAC company. Under Section 37 of the Companies Act, it speaks to variation and abrogation of rights. So the Act states that variation of the rights attached to a class of shares can only be varied in accordance with the provision in the company's articles of association, or if there's no provision in the company's articles, then the holders of that class consent to the variation in accordance with the section. And consent is required under the section. Any specified proportion of the holders of the issue shares of that class, the sanction of a resolution passed at a separate meeting of the holders of those shares. So consequently, a resolution to vary the rights of a particular class is of no legal effect unless the consent of the class is obtained. Any vote on a resolution to modify class rights must be undertaken for the purpose of benefiting the class as a whole. So the Act says, in the case of a company, the share capital of which is divided into different classes of shares, provision is made by the memorandum or the articles for authorizing the variation of the rights attached to any class of shares in the company. And it says that is subject to the consent of any specified proportion of the holders of the issued shares of that class, or the sanction of a resolution passed at a separate meeting of the holders of those shares. And in pursuance of such provision, the rights attached to any such class of shares are at any time varied. The holders of not less in the aggregate than 15% of the issued shares of that class, being persons who did not consent to or vote in favor of the resolution of the variation, they can apply to the court to have the variation canceled. And where such application is made, the variation shall not have effect unless and until it's confirmed by the court. So an application shall be made within 21 days after the date on which the consent was given or the resolution was passed. On such application, the court, after hearing the applicant and any other persons who apply to the court to be heard and appear to the court to be interested in the application, may, if it is satisfied, having regard to the circumstances of the case, that the variation would unfairly prejudice the shareholders of the class represented by the applicant, disallow and shall, if not so satisfied, confirm the variation. The decision of the court on such application shall be final, and the court would issue an order. The company has, within 15 days after the making of an order, forward a copy of the order to the registrar. And if default is made in complying with this provision, the company and every officer of the company who is in default will pay a fine of $10 per day. If the shares of the company are divided into different classes, ordinary and preference, the expression class rights refer to special rights of a particular class of shareholder concerning dividends and voting and rights on a winding up. The Act makes it clear that abrogation of class rights is included. This means that a class rights can be extinguished entirely as well as merely varied, providing the appropriate procedure of the section set out above are followed. Now, the Act also speaks to alteration of share capital. Under Section 49 of the Act, it says that a company having share capital, if it is authorized by their articles, by a resolution of the shareholders, they can increase their share capital by the creation of new shares. They could consolidate and divide all or any of its share capital into shares of larger amount than its existing shares. It can convert all or any of its paid up shares into stock and reconvert that stock into paid up shares. Or it can subdivide its shares or any of them into shares of a small amount than is fixed by a memorandum, so that in the subdivision, the proportion between the amount paid and the amount, if any, unpaid on such reduced share shall be the same as if it was in the case of the share in which the reduced price is derived. Or they could cancel shares. And the cancellation of shares should not be a reduction of share capital within the meaning of the Act. So a company's share capital may be altered or increased, provided the company follows the appropriate method and proceedings. The alterations may increase the nominal share capital, that is, redivide the company shares into shares of a greater or smaller nominal value, or the classification or reclassification of the share capital. So a limited liability company having a share capital may not alter its share capital except as set out in Section 49. That is, it is authorized by its articles of association. A limited company may make certain alterations to the provision of its memorandum of association with regard to share capital by passing a resolution at a general meeting. And unless the memorandum or articles otherwise require, the resolution may be an ordinary resolution. A limited company may consolidate its capital by amalgamating shares of small amount into shares of larger amounts. And it is rare that a company needs to consolidate, the trend being to subdivide and go for lower nominal values, which makes the shares easier to sell. You could also have subdivision of shares, and that's to make them, again, the shares more marketable. This would happen when a company subdivides every $1 share into 10-cent shares of 10 cents each. However, the proportions of amounts paid and unpaid must remain the same where the shares are partly paid. A company may wish to subdivide to make them more easily marketable. The company cannot regard some of the new shares as fully paid and some as partly paid. Reduction of capital. Why would a company want to reduce its capital? Under Section 50, a limited company may reduce its share capital by special resolution confirmed by the court, or a private company limited by shares by special resolution supported by a solvency statement. Or, an application is made to the court for confirming order. Any objection by creditors and settlements of objecting creditors. If the court is satisfied with respect to every creditor of the company who is entitled to object to the reduction, that neither his consent or the reduction has been obtained, or his debt or claim has been discharged or has determined or has been secured, the court will issue an order confirming reduction. The court may direct that the company add and reduce to its name under the expiration of the period or the time specified in the order and as part of the name of the company. The court may also order the company to publish the reasons for its reduction in capital and some other information to the public. So the Section 50 in the Companies Act states that a company limited by shares and a company limited by guarantee and having a share capital may, if so authorized by its articles, by a resolution or shares, reduce the share capital in any way, and in particular, without prejudice to the generality of the foregoing power, may A, extinguish or reduce the liability of any of the shares in respect of share capital not paid up, either with or without extinguishing or reducing liability on any of his shares, cancel and paid up share capital which is lost or unrepresented by available assets, or either with or without extinguishing or reducing liability on any of his shares, pay off any paid up share capital which is in excess of the wants of the company. The first and the last are better for creditors. So what's the process? To register the reduction of a share capital, the company is required to register the following information with the registrar of companies: a copy of the order of the court confirming the reduction of the share capital, a minute approved by the court showing with respect to the share capital of the company as altered by the order, the amount of the share capital, the number of shares into which it is to be divided, the amount of each share, and the amount, if any, at the date of registration deemed to be paid up on each share. On registration of the order and minute and not before, the resolution for reducing share capital as confirmed by the order. Notice of the registration shall be published as the court directs. The registrar certifies the registration of the order and minute, and the certificate shall constitute conclusive evidence that all the requirements of the act with respect to the reduction in share capital have been complied with. Once registered, the minute is substituted for the corresponding part of the memorandum and is valid and alterable as if it had been originally contained in the memorandum. And lastly, the substitution is deemed to be an alteration of the memorandum within the meaning of section 29. So subject to claims by creditors, a shareholder of the company, past or present, is not to be liable in respect of any share to any call or contribution exceeding in amount the difference, if any, between the amount of the shares as fixed by the minute and the amount paid, or the reduced amount, if any, which is to be deemed to have been paid on the share, as the case may be. You also have under the CAC redeemable shares. The provision for redeemable shares is to encourage investment and equity in small businesses. In circumstances where the proprietors, often members of a family, can at an appropriate stage buy back the equity investments without parting permanently with family control. So a limited company may issue redeemable shares and may be issued as redeemable at the option of the company or the shareholder. The articles of a private limited company may either exclude or restrict the issue of redeemable shares. But a public limited company may only issue redeemable shares if authorized by its articles. Redeemable shares may be issued only if there is an issue other shares which are not redeemable. If all the company shares are redeemable, then this would circumvent the perpetual succession feature of a company. So you can't have all of the shares as redeemable shares. Redeemable shares may not be redeemed unless they are fully paid. The issued capital is the creditor's buffer, and this is the figure and not the paid-up capital which must be replaced. It may be agreed between the company and the holder of shares to be redeemed that payment is made on a date later than the redemption date. Financing the redemption. Redeemable shares may only be redeemed out of distributable profits or out of the proceeds of a fresh issue of shares made for that purpose. Any premium payable on redemption must be paid out of distributable profits of the company unless the shares being redeemed were issued at a premium. The creditor's buffer in common law is the company's share capital plus non-distributable reserves that cannot be written off to pay dividends, such as the capital redemption reserve and the share capital account, the share premium account. So under section 55, the notice to registrar of any changes in share capital must be done within 30 days of the share consolidation, division, conversion, subdivision, purchase or otherwise acquired or canceled or stock reconverted. So under section 44 of the CAC, the Companies Act provides that a limited company having a share capital may purchase its own shares subject to the provision set out in section 44. Subject to its memorandum, a company may purchase or otherwise acquire shares issued by it. However, a company may not make any payment to purchase or otherwise acquire shares issued by it if there are reasonable grounds for believing that A, the company is unable or would after that repayment be unable to pay its liabilities as they become due, or B, the realizable value of the company's assets would, after that payment, be less than the aggregate of its liabilities and issued share capital of all classes. A purchase or acquisition of shares under this section shall not be a reduction of share capital within the meaning of the Act. A company may purchase its own shares for the following reasons. A private company may purchase its own shares because it gives their shares some marketability. 2, in family companies, the shareholders may not agree how many shares each should take if there is a death of a shareholder or resignation or retirement of a shareholder. They prefer for the company to purchase the shares rather than inviting an outsider to become a shareholder. If there is a shareholder dispute, a compromise can be reached by the company buying out the shares, again, avoiding the introduction of an outsider. And 4th, it is also useful when an executive director who has taken shares decides to leave, the company can buy his shares so that he severs his ties with the company. So looking at all the different provisions that the Company Act makes in terms of shares, where you allowed, after you've decided what the capital is, you've issued the shares, you've given consideration, then the act gives you the power to acquire and hold your own shares. It allows you to cancel the shares. You can alter your share capital. You can reduce your share capital. And then it gives you the process to follow in terms of making sure that the information protects the minority. And also that you have to advise the Registrar General of any changes in the share capital. So, can someone tell me why? Why would a company want to reduce its share capital? What do you think are some of the common reasons why they'd want to do that? Anybody to think of a reason why?
To offset losses?
Yeah, in a way.
I was thinking, so as to interest more investors to buy at a lower rate. I don't know.
To reduce its capital?
Yeah.
Liability.
Okay. I mean, y'all hitting on the words, right? What you say? What the word you said before liability?
To reduce the liability of any of the shares. For the shares that are not paid up.
Mm-hmm.
And then they say to pay off any paid up share capital, which is in excess of the ones of the company.
Mm-hmm. So you could use it they could use it to purchase their own shares. Or they could use it to pay dividend to shareholders.
I Googled it. Does that count?
No, that's fine.
So it says a company may want to reduce its shares capital for various reasons, including to create distributable reserves, to pay a dividend, or to buy back or redeem its own shares, to reduce or eliminate accumulated realized losses in order to be able to make distributions in the future, to return surplus capital to shareholders. Like that summed up.
Mm-hmm. Yeah. And then it could also reduce the capital by doing what? Could carve out certain parts of the businesses. So what happens when a shareholder dies?
Redistribution.
Or they could transfer it to, if they own the share, they could, if they have a will prepared, transfer that particular share to somebody else, or is it sold back to the company?
Everything depends on,
The company can purchase shares.
You said everything depends on, you mean like the Meminards?
yes,
Right.
don't forget now, when the members come here, they make a decision as to how they want the company to operate. So they can make the articles that
Right.
if the person dies, that the existing shareholders have first. Everything depends on what they agree. So normally, if no provision is made, once the shareholder dies, his interest passes to whoever inherits it. But I know sometimes the articles would speak to an existing shareholder having a first right towards those shares. So it says a person or entity to which the shares are willed or entitled under intestacy is required to show evidence of entitlement, either by the grant of probate or letters of administration. And they present this to the company in order for interest in the shares to pass in law. The transmittee may, subject to the articles, choose to become a registered shareholder or member of or transfer the shares to another person or entity for money or consideration. Once the company recognizes and verifies the transmittee's entitlement to the shares, the entitled to those shares must be properly documented in the share register. A new share certificate in the name of the transmittee or his transferee must be prepared and issued. So we know there are different types of shareholders. You have common shareholders, preference shareholders, Class A shareholders, majority shareholders, Class B shareholders, minority shareholders, nominee shareholders. All kinds of different types of shareholders. But one which we have in the Bahamas is nominee shareholders. And nominee shareholders is normally an arrangement made on behalf of the beneficial owner. So a nominee shareholder is an individual or it can be a corporate entity. And they hold the shares of a company either directly or indirectly on behalf of the ultimate beneficial owner. And in whose name the shares are registered in the share register. The nominee shareholders are normally used for reasons for anonymity and convenience. So what that means is that Mr. A incorporates a company and the shares are owned by 123 Company. 123 Company in turn would have signed a declaration of trust stating that they're holding the shares on behalf of ABC. So these services, nominee services, are offered to clients whose identities, business dealings, and characters have met strict KYC. Under the Bahamian law. And of course, international best practices. The nominee shareholder arrangement is a type of agency relationship where the nominee shareholder by holding a company shares in his name for the ultimate beneficial owner of the shares, acts as an agent on behalf of the ultimate beneficial owner. As an agent, the nominee shareholder owes the same duties and responsibility to the ultimate beneficial owner as any agent would owe to his principal. So that means he has to perform the duties imposed on him by the express or implied terms of the agency agreement. He has to act strictly within the limits of the terms of the agency nominee agreement and his actual authority. In consideration of the agency arrangement and the duties and obligations inherent in such a relationship, the potential liability that a nominee shareholder would incur would be primarily one toward the ultimate beneficial owner of the shares for breach of warranty of authority. If the nominee shareholder exceeds his actual and apparent authority to act on the principal behalf in any way. So that means that when the FCSP enters into that nominee relationship, which translates to being an agent of the principal, he in turn now has to make sure that he acts within the authority that was given to him within the contract. The principal may ratify the acts of the agent. So if he acts outside of his scope, the principal, the ultimate beneficial owner, can ratify it. It's important that the provisions of the nominee agreement between the ultimate beneficial owner and the nominee shareholder states clearly and comprehensively the nature and the ambit of the nominee shareholder relationship. The duties and responsibility of the nominee shareholder, the extent of the authority of the nominee shareholder to act on behalf of the ultimate beneficial owner in that capacity. So towards third parties, the nominee shareholder has the same liability as an ordinary shareholder, which is liability for any amount that remains unpaid on shares issued to him in a company limited by shares. So on a strict interpretation of the nominee shareholder arrangement may cause some legal academics to surmise that the potential liability of a nominee shareholder is, in reality, just a legal fiction. Since a nominee shareholder has no real or practical liability, any legal obligation or liability with regard to the shareholding remains the obligation of the ultimate beneficial owner of the shares and not that of the agent. So it's normally highly recommended that strict KYC requirements are carried out on behalf of the ultimate beneficial owner, making sure that you have and you verified the client IDs, that you know about their confirmation of their address verification. You would also try to obtain the character reference and a banking reference, so you know exactly who you're dealing with. A financial corporate service provider or a financial institution may wish only to provide service to well-known or existing clients. And they do that on a case-by-case basis. But that doesn't mean that go ahead.
This is even for CAC companies, like those all of those requirements are necessary for them as well?
Yes. And when you say CAC, you mean CAC for local
Right,
businesses?
right, local businesses.
Unless those businesses are regulated by the central bank or the insurance commission or securities commission or the gaming commission, it's the same requirement. You have to know who the clients are.
Right.
They're the
Okay.
only ones that are exempted.
What would be the risk to registered offices that take on clients without those details?
Money laundering.
Who's held liable?
Well, the FCSP itself that is like here would be breaching the laws.
Okay, okay,
Yeah. Because remember now, because they are licensed, they are required to adhere to the local legislation. And just like how a bank does its onboarding of clients on a risk-based approach, the same thing a financial corporate service provider has to do. It has to categorize its clients on a risk-based approach. And it also has to monitor those clients. So even though you're not monitoring for transaction, you're monitoring, looking at the frequent changes, or sometimes you see the ultimate beneficial owner would change of a company every 2 to 3 years. And then it also changes name at the same time. So that means that the company, you no longer have bearer shares, but the company is constantly changing hands. So in order to provide nominee shareholder services, the financial institution must apply to the central bank for a restricted nominee trust license. A nominee trust license is a nominee company which has obtained the restricted license from the central bank and it holds securities and other assets in its own name on behalf of clients of its parent bank or trust company, but carries on no other trust business. The minimum capital for such an entity is $10,000 annual fee. So notwithstanding the nuances of a nominee shareholder arrangement, one should note that under company law and in consideration of the legal underpinnings of an agency agreement, the shares of a deceased member of a company, in this case, the ultimate beneficial owner, normally devolve on the personal representative or the deceased member's estate by operation of law. And the deceased member's assets are distributed in accordance with the provisions of his will or the rules of intestacy if he dies intestate. So therefore, on the death of an ultimate beneficial owner and subject to the provisions of the Articles of Association, shares held by a nominee shareholder on behalf of an ultimate beneficial owner cannot be disposed in any way that the company chooses, since the legal ownership of such shares is that of the personal representative of the ultimate beneficial owner and not the nominee shareholder. Now, shareholders themselves have certain contractual rights, and they also have legal rights. And these are outlined in the memorandum and articles, and they're also enshrined in law. Shareholders have certain statutory rights under the Companies Act and the IBC Act. Shareholders may also have rights, privileges, and powers which are specified in the shareholders' agreement. And these rights may also be enshrined in the Articles of Association. The general law may protect shareholders of private companies from fraud, illegality, or the unfairly prejudicial conduct of the company's affairs, but it cannot protect them from the consequences of dissension within the company. Excuse me, between its directors and members, because it is not the function of the court to review the merits of business decisions taken by the board of directors or the shareholders. Certain protection of shareholders' rights should be drafted in the articles of association in order to ensure legally and contractually the rights of shareholders are observed and protected and maintained. So relevant corporate documents to shareholders' rights are the articles of association, the shareholders agreement, the nominee shareholders agreement, the declaration of trust, the register of members, the resolution of members, common law, and of course, legislation. So shareholders agreement. The shareholders agreement is a contract between the shareholders in which they agree how the company should be run. The shareholders normally agree to use their voting power in the company to ensure that the terms of the shareholders agreement are complied with. A shareholders agreement is a contract between the members themselves from which they can sue and be sued by each other. It binds each member to the company by the provisions outlined. Shareholders agreements may not suit all circumstances, but they should normally be considered when there are 2 to 20 shareholders in a company. The shareholders agreement is designed to protect all parties to the agreement against a majority of shareholders using their voting powers to the detriment of other shareholders. Without a shareholders agreement, a company will normally be under the control of those who hold a majority of the votes at directors and shareholders meetings. It's important to have a shareholders agreement in certain circumstances, particularly where there are issues which affect the running of the company or the interests of individual shareholders. A shareholders agreement can specify which decisions require all or certain shareholders to agree. Some provisions typically found in shareholders agreements are: 1, they require consent to be obtained from all of a specified majority of shareholders to appoint and remove directors, payment of salaries or fees to shareholders, and extend company loans. Second, it could include an outline which management decisions may be made by directors and which must be referred and determined by the shareholders. 3, it can have acceptable company borrowing limits. 4, approval process for directors obtaining consent to be involved in a project or business venture which may conflict with his duty as a director. And 5, circumstances into which the shareholders may approve contracts, hiring practices, or the commencement of legal proceedings. Shareholders and directors have 2 completely different roles. Shareholders own a company, directors manage the company. Unless the articles of association specify, a director does not need to be a shareholder, or a shareholder has no right to be a director of a company. It's important to make the distinction between shareholders and directors, not only to determine who owns and manages a company, but also to determine who can make decisions regarding the company in a directors meeting, shareholders meeting, or general meeting of a company. Some decisions may be made by the directors, but only with the shareholders' consent. The articles of association of a company normally specify the requisite number of shareholders and directors which issues regarding the company may be made by shareholders or directors, what meetings may be called and organized by shareholders and directors, how shareholders and directors may vote and participate in certain meetings, and what powers do shareholders and directors have in the name of ownership and management of the company. The relationship between shareholders and directors is a complex one. The directors are subject to the general fiduciary duty to act in the company's best interests. They are required to account to the shareholders for the preservation and profitability of the assets of the company. So even though the directors are responsible for the daily operation of the company and to make certain key decisions which may affect the company, the shareholders of a company normally have the ultimate source of power, as they have certain powers to appoint and remove directors or give their consent to major decisions. Now, I'll have Mr. Pratt send you all a document that you can read, and it talks about shareholders agreement and what it can typically be found in a shareholders agreement. It explains what it is, and it also tells you what should be normally included in a shareholders agreement. So we'll go over that next class because I want you to be able to read it and see if you have any questions. Because one of the key things you find out when you have 2, 3, 4, 5 persons come together to form a company, they do not draft a shareholders agreement. And so when there is a dispute, it becomes a very, very bitter exchange because the shareholders didn't sit down and plan how they would like the company run. So I want you to read this document that I'm going to send to you called the shareholders agreements and look and see what these lawyers have written as to what really should be in the shareholders agreement. So talk about dividends because that's what shareholders are looking for. Ordinary shareholders may be paid a dividend in respect of their common and ordinary shares only after all the preference dividends have been paid to date. If the preference shares by their terms of issue have priority for repayment of capital in a winding up or on reduction of capital, only after the preference capital has been fully repaid. Shareholders of preference shares rank in priority to shareholders of common ordinary shares. Debentures, debenture stock, loan stock, and notes, and preference shares are known to an ordinary shareholder as prior charges, which are securities which will absorb a fixed amount of the company's income and a fixed amount of his assets before he has any entitlement. Ordinary shares are known as equities of risk capital. Although payment of dividends for shares held by ordinary shareholders is postponed or subordinate to payment of dividends for shares held by preference shareholders, and although they bear the risk of the company's profits and assets proving insufficient, there are some advantages afforded to ordinary shareholders. Where the preference dividend is fixed and cannot be increased, however large the company's profits, the whole of the residual profits of the company after paying the preference dividend may be paid out as a dividend to the ordinary shareholders. In a winding up liquidation, when preference shareholders with priority for repayment of capital have been repaid, the nominal value of those shares, unless the preference shareholders are expressly entitled to participate in the surplus assets, the whole of the remaining assets of the company will be distributed among the ordinary shareholders. The ordinary shareholders may be able to receive back the nominal value of their shares several times over. Most of the voting power at general meetings will belong to ordinary shareholders, and it is they who will control the affairs of the company and appoint and remove its directors. So due to the greater risk he assumes, the ordinary shareholder expects to receive a higher rate of dividend on his shares than is paid on the preference shares. And when the capital of the company is used profitably, the profits earned by the company should be more than sufficient to pay the fixed interest or dividend on their securities. And the excess profits will go to the fund out which dividends on the ordinary shares are paid. The volatility of ordinary shares makes them known as risk capital. the higher the ratio of loan and preference capital to the ordinary share capital of the company, the greater are the ordinary shareholders' expectations of high dividends when the company prospers. Conversely, the greater the risk of ordinary shareholders receiving no dividend or incurring a loss on their shares when the company experiences some adversity or hardship. So I had a question. Where did I write it down? Where did I write it down? Okay. This one is a multiple choice question. Listening?
Yes.
Okay. So a managing director of a company has usual or ostensible authority to bind the company by his acts. Which of the following sets out the full limit of his authority? A, all commercial activities relating to the running of the business. B, all activities of the company, whether commercial or not. C, such commercial activities as the board chooses to delegate. And D, those commercial activities which the members direct in general meeting. Repeat.
Yeah.
Yes, repeat it.
Yes, please.
Okay, so a managing director of a company has usual, or another word for that is ostensible, authority to bind the company by his acts. Which of the following sets out the full limit of his authority? A, all commercial activities relating to the running of the business. B, all activities of the company, whether commercial or not. C, such commercial activities as the board chooses to delegate. D, those commercial activities which the members direct in general meeting. Sharella, what you think? All commercial activities relating to the running of the business, or all activities of the company, whether commercial or not, or such commercial activities as the board chooses to delegate, or those commercial activities which the members direct in general meeting.
I'm gonna go with the members direct, the last one.
The last one, those commercial activities which the members direct in general meeting. Okay, that's D. Christina, and then Monroe, what you say?
My response was D as well.
D?
Yeah.
Okay.
I am thinking A.
You are correct. The answer is A. The managing director is responsible for all commercial activities relating to the running of the business. Remember, the managing director or CEO is responsible for the day-to-day running of the company. So D said those commercial activities which the members direct in general meeting. No. He knows he can approve all activities that relate to the running of the business. Now, the articles may speak to there being a limit or certain types of transaction that will require the board approval. But he is responsible for running of the business. Okay, so where rights are attached to a class of shares settled in a company's statement of capital and initial shareholdings and the company's constitution and articles do not contain any provision regarding the way in which the rights may be varied. They may be varied by A, a special resolution of the company, B, a special resolution and the consent of the holders of 3/4 of the class of shares in question, agreement of all the members of the company in general meeting, or D, an extraordinary resolution of the holders of the class in question. Where rights are attached to a class of shares settled in the company's statement of capital and initial shareholdings and the company's constitution and the articles do not contain any provision regarding the way in which the rights may be varied, then they may be varied by A, a special resolution of the company, B, a special resolution of the company and the consent of the holders of 3/4 of the class of shares in question, the agreement of all of the members of the company in general meeting, an extraordinary resolution of the holders of the class in question. What's your answer? It's a class of shares and they want to be varied. What's the requirement? Variation of shares.
Can you say the choices again, please?
A special resolution of the company, A. B, a special resolution and the consent of the holders of 3/4 of the class of shares in question. C, the agreement of all the members of the company in general meeting. Or D, an extraordinary resolution of the holders of the class in question. A, special resolution of the company. B, special resolution of the company and the consent of the holders of 3/4 of the class of shares. C, the agreement of all members of the company in general meeting. And D, an extraordinary resolution of the holders of the class in question. Any ideas?
Okay, sorry, I heard the options, but what is the question again?
Okay, where rights are attached to a class of shares settled in the company's statement of capital and initial shareholdings and the company's constitution and the articles do not contain any provision regarding the way in which the rights may be varied. Then they may be varied by A, a special resolution of the company, B, a special resolution of the company and the consent of the holders of 3/4 of the class of shares in question, C, the agreement of all the members of the company in general meeting, or D, an extraordinary resolution of the holders of the class in question.
Okay, I'm gonna go with D again.
D? Okay,
I'm gonna go very much so confidently with C.
with what, C?
Yes.
Mm-hmm.
Yeah, I'm thinking D.
Okay, so I get 2 Ds and a C. Why D? How you come up with D?
I said D because usually they will draw up an extra. You said it's not stipulated in the corporate documents initially. So usually
Correct.
when it's like that and a decision is being made thereafter, it's usually done by way of an extraordinary resolution. If it's not D, it's B.
It's not D, is what?
If it's not D, it's B. But I'm gonna stick with D.
Mm. Okay, if it's not D, then it's B. Why would you say B?
What was B? What was B again?
B said special resolution and the consent of 75% of the class of shares.
And C was all of them, right?
C was the agreement of all members of the company in a general meeting.
I don't know.
So which one, right? Because now I have the edge of my seat.
Yeah.
D.
D is right?
Mhm.
Okay.
It would have been B if we had the right percentage. That's not
Right,
the
the
percentage I
percentage threw
gave
me
you.
off. Yeah, the percentage threw me off.
Right, the percentage would throw you off because that's too much. So where would a preference shareholder go to ascertain the rights attached to their shares? Where would a preference shareholder go to ascertain the rights attached to their shares? A, the share certificate. B, the share certificate and the memorandum of association. C, to the articles of association only. D, articles of association and or the terms of issue. Where would a preference shareholder go to ascertain the rights attached to the shares? The share certificate and the memorandum of association, articles of association only, or the articles of association and or the terms of issue.
Share certificate?
Mm-mm.
Okay, I didn't say share certificate. Give me a minute.
I think she meant the articles because the articles state the way it's governed, state the way the company will be governed.
Yeah, I'm thinking it's D too.
If that's right, I'm going with that.
Article.
You say C?
Yes, ma'am.
So what happened to D? D says the articles of association and or the terms of issue.
Yes, D.
Of course it's D.
Of course it's D. Of
Yes, because when we were doing the notes just now, I told you that you have to be very careful with the terms of issue and you state those things in the terms of issue because that's how you get investors to come in. All right, so what type of resolution is required at a general meeting to increase the nominal capital? What type of resolution is required at a general meeting to increase the nominal capital? An ordinary resolution, a special resolution following special notice, a special resolution, or an extraordinary resolution? What type of resolution is required at a general meeting to increase the nominal capital? An ordinary resolution, a special resolution following special notice, a special resolution, or an extraordinary resolution?
I think a stock
Again?
split has to be done to increase the shares, so I'm gonna go with B.
What letter?
B.
B, okay, B as in boy, okay. Anybody else? You're increasing the nominal capital now. Choices are an ordinary resolution, a special resolution following special notice, a special resolution by itself, or an extraordinary resolution. Everybody else went quiet? What type of resolution? I believe people Googling now. What type of resolution is required at a general meeting to increase the nominal capital? An ordinary resolution, a special resolution following special notice, a special resolution by itself, or an extraordinary resolution? We're increasing the nominal capital. I have a B.
Can you repeat if this is ordinary?
Who's saying ordinary? And ordinary is what letter?
I don't remember. I think it was A.
Ordinary is A. A.
Yeah, ordinary
A is
resolution.
the answer.
So I have 2 A's and 1 B? Or 1 A and 1 B? What do I have? I need one more answer.
A.
It's 2 A's?
Yeah.
Okay, it's A. An ordinary resolution. So now you know there won't be any multiple choice on the final exam, or do you wish to have some? But there will be questions
That
on
actually-
capital, shares.
So there's gonna be no multiple
You want
choice?
some?
None. Is there's a limited amount of questions, right? Like up to like.
What do you mean? Like short answer questions? Yeah,
Right.
I normally
Or on the
give
whole.
about I don't know, 5, 6, maybe 7, and let you choose.
The majority. Oh, but the majority of the questions is long form responses.
Kind of, unless they have parts. What happened?
Yeah, multiple choice. If there's a maximum amount of questions to be asked, a sprinkle of multiple choice might actually be helpful.
Okay. I better write this down. A
No,
sprinkle of multiple choice. I don't know what sprinkle means, but I sound like about what, 10?
If it's out of 50 or 20, 20 sound good. If it's out of 20 questions.
You want
yeah.
20 questions?
If it's out of 20, so like 10 multiple choice. Out of
Okay,
20
10,
might-
10. Okay, I got you. Y'all and think about the finals and that ain't nowhere near. Okay, I put down 10 multiple choices. Can be a little tricky, hey? Okay, so on Monday, I'll send to you the shareholders agreement because I want us to actually discuss it. That's one of the, I was saying to you, that's one of the faults of most people that form a company. They do not prepare a shareholders agreement. And then when there is a dispute, they don't know how to deal with it. And then the company fails because they're so busy fighting between themselves. They can't run the company. So I want you all to be able to read this and we can discuss the shareholders agreement before we go into the directors. Okay? That sounds good?
Yes, ma'am. But Miss Archer,
Oh, I'm gonna send you all a homework question. You want one?
no, ma'am. No, that's fine.
No.
I was just about,
Like,
I wanted
Like,
to know if I could give you my email address or do I have to contact Mr. Pratt? Because
No, you can
apparently,
send it to me.
okay, I'll put it in the chat then.
Also, I didn't see the emails with the recording of the class.
I'll remind Mr. Pratt to upload them.
Okay. And did you get an updated email? Because we got an email last week saying that your previous email got hacked.
Yes, it did. Oh, hold on. Let me tell you what the email is. Oh Lord, I have it written down somewhere. I gotta figure out where to put it. I got it. I can tell you what it is right now. It's Archer Christine 1985 at Gmail. Archer Christine 1985 at gmail.com.
Okay,
Got it?
got it.
Okay. All right. So that's where I'll be
The
sending it
homework,
from.
right? The email with I saw one email with 2 homework questions. Is that the only homework questions that would have been sent? Because I
Yes,
had missed
that's
one
it.
class now. Those 2? Okay.
Yeah.
All right.
But then afterwards, told everyone to start focusing on the midterm and the
Okay.
capstone.
Right.
Yeah.
Okay.
So y'all have plenty work to do, and I don't want you to wait till the last minute and then you rush it, and then you start to cry. So yeah, we'll do directors after we do the shareholders agreement next
Not
week.
yet.
Great traders are
Great,
who
great.
are judges.
Okay.
Who else? I need my judges on there.